The Takutai Moana bill is resumed. Before we commence the debate on part 3, there were 2 votes that need to be amended because they were incorrectly announced. I'll just run through those now and then seek leave. The vote on the question to amend the definition of mana tuku iho in clause 7 was announced ayes 47, noes 73. The correct result was ayes 5, noes 115. The vote on the question to omit the words from the definition of planning document in clause 7 was announced ayes 47, noes 73. The correct result is ayes 5, noes 115. The record in each case will be corrected. No different outcome of the vote. Nothing was changed. So I'll just announce that. Now the question is that part 3 stand part.
Mr. Chairman.
Honourable Chris Finlayson.
Mr. Chairman, part 3 is a very important part of the bill, and it sets out the legal rights and interests that give expression to the customary interests in the common marine and coastal area. It has 3 parts. Subpart 1 provides for affected iwi and hapu to participate in certain conservation processes. Subpart 2 sets out the test for and rights associated with protected customary rights, and subpart 3 sets out the test for and rights associated with customary marine title. I'm going to be very interested in the debate on subpart 3 because they're very important questions, and it seems to me that putting aside all the noise and sometimes the imbecility, that we really boil down to a couple of key issues with this legislation. The first, and I think we're all agreed, is should the 2004 Act be repealed? The answer unanimously around this House would seem to be yes. The next issue, should iwi, hapu whanau have the right to go to court? The answer overwhelmingly is yes. And so the debate really is all about should the tests for determining customary title be codified, or should we simply leave it to the court? And I have to say, with the greatest of respect, and I mean that genuinely to Mr. Parker, who I think's made a very positive, substantive contribution to this debate, he and I are apart on that issue. And I have to say that I firmly believe, as I think Dr. Cullen did, that statutory codification of the common law tests does need to be retained. And I really think that to wait upon protracted legal arguments while we spend years in the courts determining these issues defeats the purpose of what many are seeking, namely certainty and equity. And there are a couple of other things that Dr. Cullen made in his excellent submission on behalf of the Labour Party to the Boast Jury O'Regan panel, and that is that provision should be made for recognition of customary transfer for some period after 1840, and I think of iwi like Ngāti Paroki Hauraki. And he also said, and this leads on to the next point, that some thought needs to be given to just what powers the possession of customary title would involve. And he said in his submission, the current provisions relating to a foreshore and seabed reserve form a useful starting point. Consideration would need to be given to the relationship to other legislation such as the Resource Management Act, and then he pointed everyone in the direction of the Ngāti Porou Agreement. So that's the second big issue that the committee needs to determine tonight. Do you leave it to the courts to determine not only the tests for customary title but also what customary title involves, or do you go with the formulation in the bill about the rights conferred by customary title? And I just say that, again, I'm in the camp of saying that you need to set out what customary marine title involves. The Court of Appeal in Ngāti Apa weren't exactly sure. They said that the burden could extend from usufructuary rights to exclusive ownership equivalent to fee simples. There's a big range there. And so the issue really becomes, are the rights that are set out in Clause 64 appropriate, and or should there be something more, should there be something less? But as I say, I think that, for all the noise, they're the key issues, and I think it would be in the interests of everyone to have a good, solid and focused debate on those points.
Honourable Shane Jones.
Not that I'm an adjudicator.
Kia ora, thank you, Mr. Chair. Now that we have returned from